Hi, I'm attorney Greg Dell with attorneys Dell and Schaefer, joined by attorney Stephen Jessup. And today we're going to talk about a case that Stephen's been battling on and off for, well, I guess I should say continuously, for 7 years. But it's one of our success stories of helping a client to get paid his disability benefits. And Stephen, this was a case with Prudential. So in this types of videos, what we like to do is talk about the background of the case, what you were able to do with the client, reasons for denial, and how we've been continuing to help the client to protect their benefits on an ongoing basis. So for purposes of getting started, what's the background of this particular claim?
You know, you said 7 years. This claim started for me back in the middle of 2014. My client was a senior software engineer for one of the largest technology companies in Silicon Valley, suffering from a myriad of physical conditions, issues with the cervical and lumbar spine, nerve pain, as well as some mental health things secondary to this. Got to the point the pain was just too much for him to be able to bear, to concentrate to do, his occupational duties. And it was at that time he decided in July 2014 it was best to, explore disability.
Now, in terms of his job, was he a high wage earner?
Very, very high wage earner. I think that was probably what would, ultimately, if we look back at Prudential's actions over these past 7 years, that's always been what their target is the fact that he was such a high wage earner.
And what was the definition of disabilities that you've had to deal with?
So initially on the long term, once it transitioned out of short term, which short term is always, unable to do your own occupation. And then under this Prudential policy, like so many of them, for the first 24 months, it was, the ability to perform the material and substantial duties of your, own occupation.
Okay. And then what happened after 24 months?
After the 24-month mark, then it turned into the inability to perform the material and substantial duties of any occupation based on training, education, and experience, which, as would evolve in this claim, given what he did for a living, it was almost like the only job he could really do, or any time that they would deny, which we'll get into later, always was a variant of the job he was performing prior to disability.
Okay, so at some point in time, they denied him?
Correct.
And what was the basis for the denial?
So interesting, they denied him leading into the 24-month own to any occupation switch, but it wasn't a definition change denial at that point. In 2016, several months before the change in definition, which was to occur in January 2017, they sent him for an independent medical evaluation. The doctor they sent him with was an internal medicine doctor, I believe, not really high credentialed with what the complaints my client had. An orthopedic doctor or maybe a physiatrist would have been a much better option. That doctor came back that he did in fact have sedentary abilities, for work, and that there wasn't anything that in that doctor's opinion that would preclude him from full-time work. So what Prudential did at that point is, in the denial, they said, well, we've determined that physically there's nothing that would prevent you from working. Oh, and since you've had a history of depression, the 24-month mental health provision is over as of XYZ date. So we'll pay you through the end of the 24-month mental health, which strangely enough didn't coincide exactly 24 months. They didn't tack it on to like a month or two after approving the claim. So the initial denial wasn't this idea that we think you can do other jobs. We just think that the only thing disabling you is a mental health condition, and our liability under the policy ends, at that 24-month mark.
Was he treating with anyone for mental health conditions?
Yes, he was seeing a therapist. I wouldn't say that if you were to look at the medical file and all the medical reviews done for the appeal, I was looking up prior to, for this video, the initial appeals we did in 2017 was over 50-some pages long. And of that, in the medical side of it, it was only a handful of pages, not even of mental health, maybe one or two. It was secondary. But for being in so much pain and all this stuff that was going on, he probably wouldn't have been treating with a mental health provider, to tell you the truth.
So as a result of his pain, as a result of losing his job, not being able to work, the financial reduction in his earnings, he was having depression about it.
Yeah, and the change in life, he loved what he did, all that. So, I've always said that if you are experiencing such horrible pain, and you've lost your job and you're in this position, if there isn't some level of it affecting you mentally, then I could see where an insurance company would attack your credibility because, wait, this doesn't bother you, all these life changes? In my experience, all the clients I've represented, there is that, it's this change in life, especially if you were a really high wage earner in a very sophisticated job. That's your identity. That was his identity. So when he lost that, of course that was a hard pill to swallow for him.
All right, so Prudential basically ignores all the physical evidence and says, well, we see you had some psychiatric treatment and you're psychiatrically disabled. Prove to us that you're physically disabled and we'll maybe consider paying you. So what exactly did you have to do at that point?
At that point in doing the appeal, volumes of medical records have been going. My client was treating with all kinds of doctors, trying to figure out what exactly was going on. There was differing opinions of the actual disabling medical condition in his spine. But we reiterated all the physical aspect of it and showed how much it outweighed, just the mental health aspect of it. Really also attacking the IME as not being the proper doctor to do it. Now, Prudential, could have, tried to do another IME with a correct doctor. They chose not to. We also submitted a functional capacity evaluation with the appeal. The argument being is all right, if you want to strip down his ability to work to this lowest common denominator of physical ability, we'll show you he doesn't, and clearly didn't through the FCE report. So we submitted an appeal. That was in 2017, and then they overturned their denial of benefits. And shortly thereafter, in doing it, also agreed he was disabled from any occupation.
Okay. You mentioned something about there were some issues about figuring out or differences of opinions about his disabling condition now on the physical side. What was that, and how common is it that you see that?
It can be very common, especially when you have surgeries. You think if there's lumbar problems and then cervical and you have surgeries, which he did, that you correct those. But you've seen complex regional pain syndrome that can develop from it. He developed something known as arachnoiditis, which his doctor that he sees is one of considered the experts on it, and it's a similar nerve problem that it's one of those things I think maybe doesn't get the type of credibility it does. The insurance companies will attack these types of things. Well, the surgeries were a success. We don't know why you continue to have these problems. So he was struggling. Some doctors I don't think believed him, because he would go and he'd see a lot of doctors trying to figure it out. And then finally, his current treating physician, who he's been with since 2017, is the one that's been treating it and thankfully too, fighting very, very, very strongly on his behalf.
And how old is your client?
He's only in his 50s now, so he's still young.
Young 50s. So he basically, you said he had a surgery, a back surgery and a neck surgery?
It was just lumbar. Then the cervical they never did.
And so basically what's happening is he's having residual chronic pain even though they stabilized his spine, and now the Prudential is basically saying, well, we don't see enough evidence to support the chronic pain. But yet on your appeal you were able to prove that. So you've continued representing him since 2017, and what has that process been like?
So we started in 2014, still in 2017. Again, they started, we went months and months, requests for information, updated claim forms, a phone interview. Then in late 2019, again, they sent him for an independent medical evaluation.
Why do you call it independent?
Well, that's what the term is in the policy, an independent medical. It's compulsory. You have no option. You do have to go. It's independent only in the sense that the doctor doesn't directly get a paycheck from Prudential, like a W-2, So it's just termed independent medical. It's not like they're sending you to someone who is employed by them, but it's compulsory.
But it is a doctor of their choice.
It is a doctor of their choice. That's correct. And this one, again, the doctor came back that he believed that the client could perform at least at a sedentary and in some things light duty capacity. And Prudential basically, echoed the prior denial, saying, well, we think you can go back to doing this occupation, not as a senior software engineer, but we still think you can be a software engineer because it only requires sedentary work.
Okay, but this is, not surprising to us, but probably surprising to people who are watching this video or have been through this, and they're saying, you're representing this client since 2014. He had already surgeries. He files a claim. They give you problems initially. 2017, they cut him off. They see him. They give you problems. They put him back on claim. And basically, it's established now he has a chronic medical issue that isn't getting better. So then someone who's probably saying, how in 2019 again did they have another doctor see him and say, he got better? We're 5 years later from when he stopped working. Forget about the years and years he suffered before. So How do they reasonably do this?
That's $1 million question. Reasonably do it? I mean, from a logical perspective, there is no reason to it. We've discussed in videos about, spinal problems and stuff like that, that once you have the problem, just the natural deterioration with age, you're going to develop problems. So when you're already compromised, the best you can hope for realistically is staying the same, staying stable. So the argument always is there's nothing in the medical records to show a substantial improvement that would see him be able to return to work. The condition hasn't improved, so if he was disabled then, he's disabled now logically, but this area of the law, unfortunately, the insurance companies do have a lot of, discretion. I guess that's, we'll put it politely that way. And they will make these decisions, and it's almost like, well, let's see if the person decides to fight or if we've broken them down enough. My client was more than willing to fight, even though he's really over them. We've tried doing buyouts. They're not interested. Social Security items are still pending and things like that. But when we got the IME report, I think part of the strength in the appeal there, besides the medical, was the fact that this doctor got very personal in his report, saying the client was acting dramatic and was flopping around and was unbelievable, and there's no credibility to his complaints. So my client gave this guy some impression. This guy, I think that blinded him to the extent that he wasn't going to give a legitimate review. There was the denial, and again, we made arguments. There was no proper functional testing during this IME. It's like they just touch you, do a quick examination, 15 minutes, and all of a sudden they can determine what you can and cannot do. So we fought him again with another functional capacity evaluation from the same person who did the initial one, actually. So being able to see the regression, and there was he wasn't as well, because also the physical deconditioning from the illness, over the years. So after another round of appeal back and forth with them saying, well, here's what our doctors say, having his doctors respond to that, they did reinstate the benefit again, in early 2020. And now here we are, approaching the middle of 2021, and we're in the process of yet another, full review.
They're considering another.
Correct. They're doing a full review at this point.
And have mentioned wanting to examine him again?
No mention of it yet, but looking back on the history of it, they would do the full review and then they'd wait a couple months before wanting it. I think one of the difficulties that they will experience in trying that, and I think that they're going to be backed in a corner just in the climate we're in. Client now lives in Southern California, and it's still very hard to get independent medical evaluations set up there just because of the current restrictions.
So I know after we win appeals for claimants, we continue to represent them to help them protect their benefits so that they can avoid a future denial. In this particular case, it seems like, did they rely on anything but the IME exam to deny the claim?
Just the IME, because his doctors have been supportive. His doctors have not, like in the attending physician statements we send to the doctors, they send back, there is none of those hallmarks where you can see, well, your doctor said you could do sedentary work, and then they try to, go off that. Nothing. It's basically just been these independent medical evaluations that they hope, something will stick. For my client's sake, and I know he would love, to eventually be done with them, because it's been very trying on him. It's impacted him, his family life. He's had to, sell property because of the loss of income and all that stuff. It's been really traumatic for him, like it has for a lot of people who have to go on disability.
Well, I think one of the takeaways from this is that, winning the appeal, which we love to do, is just step one. Step two then is let's continue to manage the claim in such a manner that if they decide to deny the claim down the road, because we can protect, but we can't stop them from denying the claim. But if you do get denied, have everything ready in such a manner that you have a great chance at getting the benefits reinstated, which is what you've been able to do twice. Had this claimant just got approved and then didn't really, maintain the claim in such a manner, then what Prudential tries to do is say, look, you might have won now, but we'll get you again in 18 months to 2 years. And so that, unfortunately, with Prudential especially, is a normal cycle that we see, that every 18 months to 2 years are going to continue to evaluate the claim, and if you let your guard down, they're going to try to step in and cut you off again. But really, it's just if they find someone who says, we think you can go back to work, then they unfortunately always rely on whoever it is that they hire and will ignore everyone else to a fault. So If you have a Prudential long-term disability insurance claim or having any issues whatsoever, feel free to give Stephen or myself a call. No matter where you live in the country, we're available to assist you, and we look forward to the opportunity to speak with you. Hi, I'm Gregory Dell, the managing attorney of Dell Disability Lawyers, and I hope you find the video you just watched helpful. We put these videos out all of the time, and we'd love if you would subscribe to our YouTube channel. Beyond our videos on our YouTube channel, we also have lots of information available on our website at diattorney.com, and we encourage you to come to our website. The goal is that we want you to be educated about the disability insurance process, and when you get to our website, you'll see that we have information all about your specific disability insurance company, your occupation, and your medical condition. And we've designed our website such that you can easily search our website to find things that you may specifically be looking for. Now, at our website, we have thousands and thousands of pages of information, hundreds of videos that you can search, plus we're building a section of reviews of all the disability insurance companies, and we have the Ask Our Lawyer section where you can go ahead and ask us any questions that you may have. Now, we realize that you may not need us right now, but you may need us in the future to help you with your disability claim, and we think one of the best ways to keep in touch is by clicking the button below and subscribing to our channel. And most importantly, again, no matter where you live in the country, we're always available. Just go ahead and give us a call. We're happy to discuss your claim and let you know immediately if we can help you.